everyone. I'll be introducing our next speaker. Just want to quickly introduce myself. I'm Hannah. I'm a human nutrition student at Mount St. Vincent University, and I'm lucky enough to have Jennifer Brady as my professor. You'll hear her talk this afternoon. So I'll welcome Naomi Metallic. She hails from Listagouche Mi'kmaq First Nation, located on the Gaspé coast of Quebec, known as Gaspésiouage District of Mi'kmaqui. She speaks English, French, and is becoming fluent Mi'kmaq. After nearly 10 years of a very rewarding practice in Aboriginal law, she moved to academia to continue her work for First Nations in a different way. Through teaching, writing, and speaking about the issues facing Indigenous peoples in Canada and how the law can be a tool for reconciliation and improving the lives of Indigenous peoples. So, welcome, Naomi.
Great, thank you so much. And I'm going to just have my phone here to remind me of how long I'm speaking for. Dalhousie Naomi Metallic, Dalhousie Listagouche. I'm from the Listagouche Mi'kmaq First Nation, and just telling you in my language that I'm very happy to be with you today. So, thank you very much for the organizers of this and for Mandy for inviting me. I was just thinking on the way over in the car that I've been working in the area of First Nations social assistance for about 10 years, and I'll end up telling you the story about it over the course of these slides. The question of basic income has come up in those discussions, but it is complicated by the sort of structural and systemic issues that have to do with First Nations. So what I hope to do in this presentation, and I'm only speaking here on behalf of myself, is just to give some education about how social assistance and welfare works in First Nations communities and some of the extensive challenges with that, to help you contextualize sort of understanding what are the issues and what the questions would be around the issue of basic income with respect to First Nations, particularly on reserve, but the question also would be for people off reserve as well. So to get started, the delivery of social assistance in First Nations communities is different legally and structurally than it is in the provinces. So if we could break it into three sort of components. One, the funding aspect, so who's paying for it. Two, whose rules apply, and three, who's delivering it. Usually in the province, you've got the province doing all three at once. But in the First Nations context, it is different than that. So just at a glance, we see that it's the federal government who funds social assistance on reserve, but the federal government chooses to model its approach on the provincial programming, so kind of brings in provincial rules indirectly through its funding policies. And it has these funding policies under which First Nations can deliver the program, but they don't make the rules. Again, that's the federal government choosing to, but using the provincial rules to do this. It's a very complicated system. And some would say overly complicated and problematic. I certainly do, and I'll talk more about that. Okay, so how did this approach to social assistance come about? So to give you a little bit of an overview of that. The delivery of the social assistance, the public safety net, really develops in Canada as an administrative state post-World War II, not just on First Nations, but across Canada. You have provinces starting to deliver and look at income assistance programs and the development of unemployment insurance provided by Canada. So this is the time when these sorts of concerns are coming to the fore. But it became apparent as these programs were starting to unroll that nobody was providing them to First Nations on reserve. The policy prior to post-World War II, there was sort of rations that were given out by the Indian agent, and there's a book all about this, talking about the policy, the federal policy up until 1946. And the title of the book is Enough to Keep Them Alive. That was basically the policy. Only give them enough to basically keep them alive was the policy prior to World War II. And so First Nations faced a number of challenges in that regard and were marginalized and prevented from participating in their traditional economies on reserve and, layer on top of that residential schools, et cetera. But coming back to post-World War II, there's finally starting to be some realization that First Nations are not receiving the same type of programming as other citizens receive when it comes to this, the creation of these new social safety nets. So there's a committee that is formed by Parliament, it's a House and Senate committee, to look at the issue. I guess the committee was well-meaning in its approach, but their solution, curiously, was to sort of say, the problem is, these special rules, having reserves, having the Indian Act treaties, they're holding First Nations people back. And the best approach would be for them to be absorbed into mainstream society. And so, previous to World War II and with residential schools, the goal was assimilation. Post-World War II, it was still assimilation, a slightly different form of assimilation, but assimilation nonetheless, with this idea that the federal government, the recommendation from this committee was, let's try to get First Nations under the jurisdiction of the provinces, and they can take over and pay for services for them. So we're seeing the beginning of what becomes a problem that continues to be a major problem, which is neither the federal government nor the provincial governments wanting responsibility or taking responsibility with respect to Indigenous people. So yeah, that's the proposal. And what happens next? Well, the federal government thought, how are we going to do this? We don't necessarily have to negotiate with the provinces over this. So they try something creative. They insert Section 88 into the Indian Act, 1951. And what that does is that it applies provincial rules of general application. So just general provincial rules apply to Indians. That's what this says. So it's sort of like the federal government kind of adopting provincial rules as its own. And I think the goal was to say, okay, haha, provinces, now they're your problem. But it didn't work that way. The provinces said, no way. You can't force us to do this. Yeah, you might say that our laws apply. You can adopt our laws if you want. But we're not going to put out the services and pay for those services. So they were extremely reluctant, most provinces, to take over social assistance or other programming unless they were completely reimbursed by the federal government. Only one province actually ended up kind of coming on board specifically with respect to social assistance, and that was Ontario. They signed an agreement with the federal government in around 1964, 65. But beyond that, none of the other provinces wanted to provide services to First Nations. And so, begrudgingly, Canada is put in a situation where it's sort of forced to act, because up to this point, even to the mid-60s, Indigenous people or First Nations on reserve are not receiving the same level of services as other Canadians are. So, like I say, begrudgingly, Canada decides to do this. It doesn't do so by passing legislation. There is no First Nations Social Assistance Act, and there's nothing in the Indian Act. The Indian Act has never really been substantially amended since 1951. There are no rules around social assistance or basic income or anything like that. So Canada sort of figured it hoped that it could eventually convince the provinces to take this over. But in the meantime, it finally decided in '64 that it was going to do something. So it got Treasury Board approval, so that's a spending approval, to provide social assistance on reserves, adopting provincial rates and standards. So it's kind of a this is the whole document pretty much. This is a cabinet or Treasury Board authority that says, yes, the Department of, at the time it was, Indians at the time were under the Department of Citizenship and Immigration. It's really a fascinating study to look at where the issues of Indigenous issues were put at various times. At one point it was under Veterans and Mines, I think. Anyway, so a little digression, but at the time it was Citizenship and Immigration, I think along the lines of this idea that at this point the mindset was that we've got to get Indians to be absorbed into the mainstream and become real citizens. And so I guess that's why they had under that department. But anyway, let's continue. So the authority was to adopt provincial and local municipal standards and procedures to provide social assistance. But there's a problem. I mean, there's 10 provinces, and the federal government wasn't legislating. So what ended up happening was that the department officials would go look at the social assistance income policies and laws that existed within the province and try their best to create one for the areas the regions that they were in. And this is more from, this was a letter that was supporting the Treasury Board request, and some recognition of how much money would be spent, and the idea was it was a means of rectifying the present inadequacy of Indian Affairs Branch scale of assistance, and so there were, the talk was to bring it up to provincial or municipal rates. And so this is around about 10 days after this Treasury Board authority is approved. This is the department telling its different regions about what the expectation or the goal is. This will make available to Indian the full range of assistance at the same scales and under the same eligibility conditions as other needy persons in the provinces in which they reside. But again, this is the issue of they're not legislating, so it may not be possible to adopt all aspects of provincial policy to departmental administration. You are therefore asked, as a preliminary step towards implementation of this new policy, to draft regulations which you feel should be applied to the administration of relief assistance for Indians. So that was a sort of marching order. So this is what we got. I found this, this next document at our archives down the street, which was the first manual for social assistance in the Maritimes. And so anyway, you get a little glimpse at what the rates and levels were at that time. And this applied to New Brunswick, Nova Scotia, and Prince Edward Island. The next time that this gets updated, just a few more things to look at, is in the 1990s. So in 1991, these manuals get updated again, and the department looks at what's going on in the various provinces at the time. And instead of having one manual for the region, they instead do one manual for each province. So New Brunswick had its own social assistance manual, so did Nova Scotia. And the department officials tried to model this on provincial social assistance policies and laws in place at the time. Interesting fact, this is the manual that is still in place today, including the rates that were in it in the rates got amended once in 1994, and I'll tell you the story about that as we go along. So we've got the manual. So again, it's sort of an adopting of provincial rules and imposing those on First Nations. And then we get this thing called program devolution. So initially, it was the federal government employees who would go and deliver and provide social assistance in the communities. But gradually, and with First Nations pushing for greater control over their affairs, although the federal government was not willing to give full control, absolutely not, instead they offered a program, something called program devolution, which is where First Nations get to deliver the services. They don't get to determine the services, but they get to deliver it. And that happens in a variety of different areas when it comes to First Nations. And this is brought into effect through funding agreements. So a lot of Canadians sometimes hear about First Nations getting money from the government. And so a lot of this is money from the government to deliver key, basic, essential services. And as you're going to find out, usually deeply underfunded as compared to the provinces. So yeah, we have these funding agreements. They're often they're in the nature of contribution agreements. And what does that mean? It means that the federal government is very strict about these agreements. The Indigenous First Nations have to follow this agreement to a T. They have to follow the standards and conditions that are required. They have to file numerous reports. There was an Auditor General report from the early 2000s that had found something like, for a funding agreement, something like 160 different reports had to be filed by the First Nation just for a year's worth of funding, reporting on how things were spent and these kinds of things. And it's been criticized severely that this really takes away time from actual delivery of services, and further that what's being reported on is not being used to inform policy development. So it's really challenging. Okay, yeah, and there's default provisions. If a First Nation, overspends and actually is in default over 8%, then it allows the federal government to kind of swoop in and take control over the band's finances. Anyway, so actually quite restrictive, controlled measures when it comes to this. So, before I go any further, I'll talk about this case. So this case began in the spring of 2011, so about 10 years. And this is where my own education on First Nations social assistance began. So it came to my firm at the time, still does, a significant Aboriginal law practice, and many First Nations that we represented came to us because they were extremely concerned about an announcement that was told to them that in a couple of months, the department was going to change its approach to social assistance from the previous 1990 policies that it had been following. It said, we haven't really been keeping, this was during the Harper years, by the way, we haven't really been keeping track with the 1964 Treasury Board Authority. You guys haven't been compliant with it. They said, you really need to be following strictly whatever the provincial rules are today. The problem with that, though, is the policy that they've been following since the 1990s, did fairly, adapt the rules that existed in 1990. But, over time, these hadn't been updated. And furthermore, the way that the government appeared to be interpreting sort of strict following or mirroring of the provincial rules would have been in ways that would have ignored realities in the First Nations, particularly around how band housing works, and would have resulted in situations where there would have been no funding for people's housing and various other sort of things. So it wasn't clearly worked out or thought out, but we did get our hands on evidence that clearly recognized that the big draw for this was primarily cost savings at the time. And the First Nations were told that this was a non-negotiable change. It was just about being compliant with the 1964 Treasury Board Authority. There was, again, no law in place, and it was a matter of compliance, and there was no duty to consult. So, First Nations in New Brunswick started a judicial review of the federal government, and then PEI First Nations and Nova Scotia First Nations all joined. So we were representing all of them. And this led to an extensive court battle that lasted about 5 years. I'll spare you all the gory details, but I think we went to court about 7 or 8 times, and we had some significant wins, and we also had some losses. But the gist of sort of what happened is that by the time the sort of litigation itself was dead, and that was the Supreme Court denied leave to appeal to us because we had a very bad federal court of appeal decision, although an excellent federal court decision that got overturned. But in any event, by the time this all ended and the dust settled, we had a new government. The Conservatives were gone, and so we had the Liberals. And so we switched gears because the concerns about the impacts of this change were still really real. And so we switched gears with the chiefs, trying to lobby government officials to examine a new approach to social assistance on reserve. So, and that's what we've been doing. And one of my last slides will sort of give you the picture of what's happened in the last 5 years. But I want to break down a little bit about the problems of social assistance, the program that I've just described to you. just sort of some of the highlights as my analysis leads to, is that the approach is still very much premised on assimilation. You know, assimilation was the goal prior to World War II, particularly with residential schools and other things. But even this idea of sort of having provincial rules imposed on First Nations in terms of applying social assistance rules, you know, it's still very assimilative in its concepts, right? And even like notions of what social assistance is a pretty Euro-Canadian or Western concept, right? Indigenous communities always, and Mi'kmaq for certain, I did some research on this recently, there's like 25 plus words in Mi'kmaq for sharing. And they're all very sort of nuanced, and when you study them as a group, you see just how important the concept of sharing is. The word sagamau, which is the word for chief, actually means he or she who distributes goods equally among the group. So the concept of sharing is not, resources and wealth is certainly not new to Indigenous people, but this idea of like you have to be in the specific workforce and sort of the concepts around Euro-Canadian social assistance or, removed from First Nations concepps, right? So it is very much premised still on assimilation. The other big thing about this is, as you might have gathered, it completely leaves First Nations out of social development policy, but it actually makes no sense because it's the federal governments who pay, and you know, they have under our Constitution responsibility with respect to First Nations under Section 9124 that says they have jurisdiction over Indians and lands reserved for Indians. And one would think that they would take that sort of responsibility a bit more to heart, but what they've done is they just borrow provincial rules. But the provinces, when they're developing their rules, are not developing rules with First Nations in mind. So you have a situation, and First Nations are not allowed to develop social assistance rules under this system. So you have a system where nobody is thinking about First Nations policy issues in the development of the rules that ultimately get applied. And that's perverse. What else? So it's certainly not culturally appropriate, right? It's based on Euro-Canadian values. Here's the quote that I was thinking of. So this is a really good one. Schulich is the guy who wrote the book that I mentioned earlier about Enough to Keep Them Alive. If you're looking him up, Hugh Schulich, but this is another article that he wrote. The idea that Indian poverty can be relieved and solutions found through Euro-Canadian welfare state measures was and is a profoundly ethnocentrically misguided assumption. Historically, like any independent and economically self-sufficient peoples, First Nations had their own ways of coping with times of scarcity and hardship. The main impact of the Euro-Canadian Social Assistance Program has been its individualization of poverty and the undermining of collective and traditional patterns of helping, sharing, and cooperation centered on interconnected kinship systems. Certainly when I've worked with First Nations in the province, I mean, this is what they really have in mind, of getting back to systems that reflect more so their own values. So I think, you know, that has to be kept in mind on any sort of project going forward. What else? Oh, I spoke earlier about these contribution agreements. The funding agreements are deeply problematic. Effectively, these are agreements for the First Nations to deliver the most basic essential programs in their communities. And this includes not just social assistance, but housing and education and child welfare and other matters. But these are not like, the government does not sit down with the First Nations and say, how much money do you need? And, you know, what can we do? And these sorts of things. It's, you know, this is the money you're getting, take it or leave it. These are very much take it or leave it agreements with very little flexibility for First Nations or agencies working for them to do any modification to program terms to make them more culturally appropriate. There's been a few attempts to try to make sometimes the funding from different pots from one to another a bit more flexible, but in practice that has not actually been the case because the programs are so deeply underfunded. That it's not any real flexibility. I mentioned this earlier, inordinate reporting requirements and controls over First Nations by the government, and it's not self-government at all. Sometimes I think people looking from the outside see government's funding going to First Nations and they sort of think it's self-government, but it's certainly not. And it's not appropriate for a nation-to-nation relationship. Being a lawyer, I'm quite concerned about the rule of law and have written quite a bit about how this whole system, because it happens in a legislative vacuum, is very much violating the rule of law, as understood in cases by the Supreme Court of Canada, right? So rule of law includes this idea that we have a positive set of laws, written laws that bind the government as well as citizens, and also sets out, accountability of government to citizens. And when you don't have this, and you have instead what the federal government uses for most of its First Nations policies, is, funding agreements, Treasury Board authorities, and policies. There's a lot of flexibility available there for the government to maneuver, and not a lot for the First Nations to cling to hold the government accountable and keep their feet to the fire. So it also creates huge access to justice problems. So these funding agreements have these dispute resolution clauses, and they're kind of hilarious because they say, yeah, there's a dispute resolution mechanism if you don't, with the funding agreement, except you can't challenge any of the you can't challenge any policy decisions, and you can't challenge any funding decisions, which makes it a fairly useless dispute resolution clause, but that's how they've been framed. And trying to go to court, especially without a legal framework in which this is ensconced, makes it so difficult. The case that I mentioned earlier, Simon, at one point the government lawyers tried to make this argument because there's no laws, because this is just funding, this is all discretionary, there's actually no role for the courts. You don't have to hear this court, even though significant human rights violations were happening, I would say. And the court almost went that way, but they said, well, the policy here is sort of like a legislative mechanism, so we can review it. But the problem is that there's far too much discretion, and it allows the government to a lot of wiggle room, including wiggling room around concepts. Like, the whole idea was that the federal government was supposed to provide a program that was, quote unquote, comparable with the provincial systems. But the government of Canada never really monitored or studied or actually determined whether it was providing comparable services. We've done more research in the last 5-6 years, and that very much confirms that it has not. And in another area on child welfare, there was a Canadian Human Rights Tribunal decision from 2016 where the tribunal held that with respect to it's a similar system too. With respect to child welfare, Canada had been knowingly underfunding this program for over a decade. So this violates the rule of law too because there's so little ability to hold governments accountable. And I guess just to show this whole issue around, I mentioned human rights violations. This was one of the documents that came out in the discovery of evidence when we had the case. And this was a memo put together by people who worked at the department at the time. I have removed their names. But it was a memo staff created at the Regional Department of Indian Affairs, identifying what the risks would be of going forward with these changes, which totally backed up our claim that this was going to be disastrous and make poor people even poorer. But, so the first paragraph you see there, the effect of moving to compliance with national program authorities is a significant lowering of amounts received by income assistance recipients in many cases, in addition to scaling back of shelter and fuel allowances. And if you look at this chart, this risk assessment chart on the other side, it's just wild. It recognizes that people are going to be so angry that they might be doing violence to people who work from the department because they've impoverish them so much. There's also recognition that this could bring a legal challenge and a human rights challenge. And the one that kind of, really blew me away was, you see the one I've highlighted, other ANSI programs, so Department of Indian Affairs programs are adversely affected. So there's a recognition that it might impact on the housing program and funding for houses, and then increased demand on child and family services and other social programs. That means that they recognize that there would be increased apprehension of First Nations children and therefore increased stress on that program. All meanwhile, they're fighting Cindy Blackstock, who's bringing the child welfare decision at the Canadian Human Rights Tribunal. I mean, it is quite gross, I have to say. So anyway, that sort of shows, some of the problems that exist with this kind of framework. Severe underfunding issues, I've spoken to that. I think this group most Canadians are aware that, First Nations figure at the bottom of virtually every socioeconomic indicator. What you see here is a well-being index, and the yellow line or the gold line is First Nations, and the blue line is non-Aboriginal communities. I think this is from 2015, this chart, or anyway, it ends at 2011, but you see there's this persistent gap of at least 20 points. Yeah, and this case wasn't the only time that this has been raised. The Auditor General of Canada had been raising the alarm bells on this programming and system for quite a long time, identifying that the structure of it, not legislated, undermined parliamentary control, that services were provided were not comparable, it was hindering living conditions on reserve. So, but these critiques by the Auditor General sort of have gone fairly unheeded. But there has been some movement. So this is my last couple slides. I know I'm going to get to questions in a sec. So what's happened since 2016? As I said, the Trudeau government was more receptive to looking at some reform in the area. So what that meant in the Maritimes was a collaborative research project where we looked deeply at the existing program and tried to provide evidence to support our claims that the programs were underfunded. There wasn't access to many of the same programming that was available within the provinces. One of the big ones was case management and other supports. There's virtually no case management system in the First Nations context. And then we also found out that outside the Maritimes, Indigenous Services, or Indian Affairs, now we call them Indigenous Services, also funded a national engagement process to look at income reform on First Nations. And their findings, I have them listed there, you can take a look at them, but the findings are the same as what we had found in our research. Inadequate provision of services, inadequate support for capacity building, inadequate case management and pre-employment supports, lack of community-based wraparound ancillary services, and very little recognition of self-determination, governance, or traditional knowledge in any of the design of these programs. And so there was this final report, and at the moment, Indigenous Services Canada is pursuing I would say, projects with different First Nations and pursuing an incremental approach to income assistance reform. And I'm doing still work with the First Nations of New Brunswick, helping them to try to reform the system. And I think that the efforts that are being made are good, so I'm not trying to criticize that, but I think quite a bit more could be done. And one of the groups, the Quebec group, when making recommendations of this, suggested that there should be federal legislation on First Nations social assistance that should address many matters, but also recognize the inherent right to self-government as part of that. So I'll end on this question of basic income, which, so I was talking with Mandy last night about this. There are recommendations in the Missing and Murdered Indigenous Women's Inquiry about having basic income for First Nations and Indigenous people more generally. And I've heard First Nations talk about it. I remember when we started doing the research, one chief was quite keen on it. But interestingly, when we have done some presentations, some of the concern, there is a concern around basic income, which is a fear that it will result in a loss of really important programming that First Nations have largely not even had the opportunity to avail themselves of yet. So we were working, for example, to try to get a much better case management system. Like it's been non-existent in New Brunswick, for example. But yeah, there's a real great desire to be self-determining in this area, not simply just having provincial rules indirectly applied, adequate funding, culturally appropriate, and very much case management and wraparound services. Because you've got, 40 years of this system, which has just served to exacerbate poverty, and you're also dealing with, intergenerational impacts of residential schools and day schools. So you get sort of this perfect storm, right, of, people who need a lot of support and help. And so there is a worry when I've spoken to social development administrators that, and maybe it's a poor understanding of what basic income is, but simply cutting a check to somebody they think is not going to cut it, and want to see, people support it. And often the talks are like, we want people to re-engage with their culture, go hunting, go fishing, relearn their language as part of this sort of overall healing of so Indigenous concepts around this are often sort of wrapped up in a more holistic idea of what it is to help people, live meaningful lives. So it's a difficult conversation when we're about basic income, because I don't think it's a hard no, but I do think that the real structural problems around income assistance in First Nations communities and this sort of historic and ongoing discrimination in the area sort of really complicates the issue. And yeah, because the problems with social assistance are still so acute and still bluntly colonial. So on that very cheery note, I will leave it there and open it up to questions. Thank you.
Thank you very much. I really, really appreciate the talk that you gave, and I think it's important to understand all of the complexities involved in making decisions around this. And so, is there a question that? Okay.
Thanks, Mandy.
Thank you so much. My first question is just sort of a simple one, which is, what did CERB look like for First Nations?
Yeah, so the way that the Indian Affairs dealt with it is that they didn't take they basically, whatever the rules are in the province so if the province of New Brunswick clawed back social because somebody got CERB, they would do it. If another province didn't, they wouldn't. So that's how it kind of went.
Okay, thank you. Is it okay to ask another question? Okay. So my other question, and it was just in the news like this morning, so if you haven't even heard, no problem. But I heard in the news this morning that Sibiganagati First Nation just evicted their child and family services from the community. And I wonder sort of if you could provide any background on that, or if there's any movement towards sort of evicting those colonial services on resume.
Yeah, so that one is more complicated. So we're getting into the issue of child welfare. And I didn't hear about that, but there was a similar news story from last week with a BC First Nation, I think, doing something sort of similar. So in Nova Scotia, we do have a Mi'kmaq child welfare agency that has, so it's an attempt to make a sort of agency more culturally appropriate, but they're still bound in several important ways to following provincial policies. Mi'kmaq in the province have been working for the past 4 or 5 years on developing their own child welfare law. And this is slightly a little off track of social assistance, but there is actual federal legislation that was passed last year that allows Indigenous communities to develop their own child welfare law. So that's being worked on, but I don't know the context of the frustration or what specifically triggered the community to take that position. The idea of having a Mi'kmaq child and a child welfare agency was to make it more culturally appropriate, but again, they were limited, and I've certainly heard some complaints of the communities of feeling that their hands were too restricted, or perhaps they were to follow provincial rules perhaps too strictly. So I don't know more about that, but it's all it's various sort of factors at one time sort of addressing this. I mean, to link it back to social assistance, which often sort of gets missed in conversations about child welfare, is that, a lot of the poverty in First Nations communities is fueling why children get apprehended, right? So, I mean, there's a huge connection. And it's funny because of Cindy Blackstock and the amazing work she's done, we've had this sort of like focus on child welfare, but there's like, there are parts of the human rights decision that said, but like it all feeds into it. Social assistance, housing, access to food are all related. But the government tends to still take this really siloed view of like, oh, we're fixing child welfare. It's like, well, you got to fix social assistance, right? And I mean, there's some communities where you might have 80% of the community on social assistance, so it's significant. Not every community. There's some that have significant employment, but yeah, it has to be. They are related for sure. So thank you for that question. Yeah. Oh, there's a guy over there, but then we have a gal over here. Okay, guy over there.
Anyway, you're going to hear a lot of background when I do my speech a bit later on why I'm asking the question I'm asking, but does this system of social assistance you speak about in Quebec / the First Nations community, does it have a lot of like strict and rigid rules around stuff? Like, for example, if you decide you want to cohabitate with someone and you have like someone in your life who you want to call a romantic partner or spouse, that prevents you from trying to live with them. Also, if you need per se a special needs allowance, is there systematic problems involved with getting qualified for those type of allowances? And there's a lot of examples I can give, but I want to be respectful of time, and you're going to hear, as I said, more about the background on why I'm asking this question when I do my speech at 5 after 2.
Yeah. Yeah, so you're absolutely right, and the answer to your question is yes. Because these programs are modeled on provincial programs, so clawbacks, as you say, and also issues where people try to cohabitate, and then it leads to all kinds of situations where people have to lie about or sort of change their situation, and they're not making enough money to begin with, and then but like they're sort of forced into a situation where they are actually with someone, but for various purposes are trying to pretend that they're not, because then there'll be a clawback of their funding. So those same rules, those punitive rules that really make it hard and don't really reflect what people really need are operating in this system too.
Thank you.
Thank you. Yeah. Oh, you need a mic.
Should have worn my sneakers.
Thank you very, very much. This is fascinating. So my question is probably really big and unfair, but if we play a mind game and assume that we move to a basic income world where the federal government actually does assume full responsibility for income security, as it's done for seniors and kids, if we have a basic income world, what does the rest of the on-reserve ecosystem of all of these other services and things mean? Because there's no provincial rules anymore if there's no social assistance.
Yeah.
So how do you see the rest of it working?
No, I think it's a great question, and I don't I don't really have a great answer. I think that there's issues, right? So yeah, I think that would have to be deeply negotiated with different First Nations. The Assembly of First Nations has a working group on social assistance, but yeah, there's a real fear that if it or there needs to be, what my final point was that when we're talking about this issue is that First Nations want to develop their own system, which tends to build in a lot of like support for people. And I guess the fear is, and I don't know, so I'll ask the question back to you, is the model that you posed to me, this federal model, would it include supports? Would it include supports beyond a paycheck?
Yeah, so what we're proposing in our modeling is that, there's a difference between income and other services, and they just do really different things. And the way the child benefit system was designed, the framework was that the federal government assumes the major role for income security. So it takes the income part of things, and that it's, in that case, provincial and territorial governments, but in this case it would also be Indigenous governments, and like on a case-by-case basis, that they would be responsible for the services and other things that are closer to people that actually require, community and being with the people and the involvement of people in designing those services. But you take the income part of it out of it.
Okay.
Like the federal government does that. And then with child benefits, what many of the province and territories did was a combination of additional income supports, but still services. And you design those services to meet the need that remains once you've taken many of the income problems out of the equation.
I mean, if that is the model, then I think that there would be receptivity to it without having, you know, thought every element of it through. What Indigenous communities wanted to be, really the ability to be able to design services that really work for their communities and to have adequate funding to provide those services, which are two things that we've been, you know, largely denied for 50 years, and which has, you know, then become this sort of vicious cycle as, you know, conditions get worse and people get, you know, more dependent and have more difficult times becoming self-sustaining. So if those two conditions can be met, I think that, you know, Indigenous people would be receptive to that for certain. Yeah. Anyway.
Hi, Naomi. How you doing? My question is, you know, on the National Municipal Basic Income call, at one point, the mayor of Whitehorse challenged the rest of us to get with the program with Yukon and have proper, I forget what the technical phrase is, but effectively soup to nuts modern treaties that they were just signing, like Tulsa Tinglet, and they just signed another one last year. Do those include or not include social assistance? Like when we're doing a treaty in 2021, yep. in the BC Interior, is that on the table, or
it
are
is.
They? Oh, amazing!
Yep.
I'd love to hear about that.
It is on the table. Not all groups have. So I did get a student a couple years ago to take a look at who is self-governing in social assistance. The Nisga'a are. The Nisga'a have their own policy, and it's developed. So if you want it, I have a copy of the policy. We looked at some of the Yukon self-governing First Nations, and one had started to really sort of dabble more in policy development. The rest tended to, at least for now, because they're, you know, implementing self-government's a big job, so I think they're sort of being strategic in what they're starting with, but so some of them haven't, and they were still largely using provincial rules in order to develop, or at this point, but Nisga'a would be a clear example, and I think there's other groups who want to. Yeah. So there are some models, yeah. The best models are in the US. Right? The US has such a better track record in terms of self-determination and self-government, and they have all kinds of legislation that supports and enhances that. And in the US, it's called TANF, and it allows the tribes to essentially design their own programs. There are some controls, but not a lot. But I've got some information on that too, if you want me to send it to you. Yeah. Hi there.
Hi. This is a little bit connected to Sheila's question, I think. You mentioned there was a chief and there were some people who, in the Indigenous community and leadership, that were interested in basic income. And I wonder if there's any sort of vision on the part of those people of what an Indigenous-led sort of basic income could look like.
I haven't seen a lot of writing on it yet. So there's certainly been a few people, and I'll probably have Fred Ween sending me an email at some point. I wish we worked on some of these projects together. We had brought some experts that had looked at a basic income, but more sort of on the sort of more general level. So to my knowledge, there hasn't been a lot of like looking at that sort of specifically, and perhaps as a similar response to this question from this nice lady over here in the beautiful green shirt, I think is you know, if there was room to vision it, and it was if the First Nations could be reassured, and you know, the two things that I think that are clear that they want, which is self-determination, the ability to design systems that work for them. Recognizing that, you know, we come from cultures where we do really want to support each other, and we see ourselves more as a collective than individuals. So often the programming is stuff that we want to help other people live their best lives, and so and have it be fairly culturally informed, and also, you know, adequate funding to provide those services. So I think if those two conditions are met, as I was saying earlier, then I think that communities, you know, would be receptive to sort of dreaming about what basic income could look like.
Naomi, first of all, thank you very much for your talk. I think I've learned more in the last hour than I have since the 50 years that I've been in Canada, so thank you very much.
You're welcome.
But what I wanted to ask in terms of the spirit of going forward in terms of basic income, I think we all probably can agree on that we want the same thing, and that is eradication of poverty. And the poverty in the Indigenous community is much deeper than it is in the rest of Canada. But do you see a possibility forward for the basic income movement and the Indigenous groups to work towards the eradication of poverty?
Yeah. I believe so. Again, I'm speaking only as Naiomi Metallic, right? But I mean, I have worked with different communities. There are leadership organizations, right? In Nova Scotia, that would be, you know, the Mi'kmaq Rights Initiative. They have an office in Truro. They have various staff that work for them. And, you know, and they have been working on their own project on social assistance. I'm not as familiar with it. I've been helping the groups in New Brunswick with that. But definitely worth a conversation. But I think also helping to illuminate what the vision would be of it, because again, whenever it's been raised, I think, and maybe not explained clearly enough, but when it's been raised, the fear has always been, oh, but that's going to mean a clawback. It's just going to be a check, and there's going to be a clawback of all these other services, and we need to provide all those services. But you know, I think that they would be receptive. So, I mean, I would, you know, potentially, if this group who's thinking about basic income in Nova Scotia would want to reach out to the Assembly of Nova Scotia Mi'kmaq chiefs and the organizations that support them. They have an executive director. I can give Kay all the information, she probably knows. But, you know, coming and making a presentation, talking about it, because certainly the chiefs, especially in the last 10 years with that case, they want to address poverty, right? And so that is the main goal. So you're working towards the same goal. So I'm sure they would be receptive to listening and finding out more and seeing what they're currently doing and how you can be allies to work together. Because, you know, it's not all fixed in terms of the government is working with us, but they're taking a very incremental approach, and to the extent that they can, they still are trying to, you know, not fund many services. So there's still some advocacy and support we need on that front as well. So yeah, it's worth a shot. There's one more question.
Hi, thank you so much for this presentation. This has been exceptionally informative, and I'm also going to ask a question that's probably completely unfair as we talk about legislation that's
okay.
unfair
The
and a
bar's
history
been
that's
set.
unfair. Were Canada to, building on other people's questions, were Canada to implement a basic income for Canadians, it would be assumed that that would be also extended to First Nations, Inuit and Métis as well. And that would, of course, be done in a very symbolic presentational way, although we know that there would always be these conditions that would fight constitutionally with a history of clawbacks and stratification, and you get this as long as you get this, and it's on condition, and then we get lost in the history of what we've had forever. Would a universal basic income given to Canadians broadly based in a rights form versus a policy form, would that be a better idea, generally speaking? Once again, not a very fair question, but if it was based on rights, a rights form in which, if it is, even for Canadians, let's go with that first, it's not being met, the right is violated, there is legal recourse, would that address to some degree the history in which the services have gotten lost constitutionally between province and federal systems and have been based on policy which changes every government, and it's not based, and the Auditor General said that there isn't a suffice way to address it legally because it's not based in rights, it's based on conditions.
Yeah, I definitely think it has to be, the solutions should be based in a legal framework. I mean, right now the work that the communities are doing is primarily just trying to continue to negotiate with ISK, and it's going to be via more their policies. But I still think structurally, and I've told this to the First Nations that I've worked with, like we have to work with them now with what they're offering, because there's real poverty in the communities. But we should continually, and maybe with other groups like the ones in Quebec who are very strong on seeing legislation, working towards a legislative framework for this to be ensconced in, because it has to be rights-based, and it hasn't been viewed as rights-based and just policy-based. And I guess the only other point that when you were speaking, and I think to another question, that I will probably end on, which is in that Canadian Human Rights Tribunal decision from 2016 on child welfare, one of my favorite aspects of this case that I come back to, and I've written some articles on it, talks about the right to a substantive equality, and that Indigenous people are entitled to substantive equality. And in that case, they actually say, a comparability approach and just being an identical treatment to other Canadians is discriminatory. And they talk about how substantive equality means meeting the needs and circumstances, including historical and geographical. So I guess that would be the other key point that I didn't say explicitly yet that I wanted to just sort of leave on, which is, when we're thinking about this, like a general approach is good, but we have to realize because of the context that substantive equality means more than just treating it just like other Canadians.
Yeah, because it's based on norm cultural differences.
Yeah.
So you'll have a norm cultural difference that's different than my Chinese cultural difference, different than a European cultural norm. And we'll just say, oh, it's all generally the universal, but it's not. It's not actually universal.
I mean, there's that plus the weight of the history and colonialism and these policies that continue to really still impact people's poverty. Thanks, Kay.
Yes, within Canada, absolutely. Thank you so much. This has been a wonderful talk.
Thank you. Thanks, Wei.
We've learned a lot, and I really hope that you can help us to understand issues related to basic income and First Nations communities as we move along towards hopefully implementation.
And I definitely think speaking to the groups, right? So I can give you my academic and analytical things, but I don't speak for anyone, right? So I don't want to pretend that I'm talking for the Mi'kmaq of Nova Scotia on how they feel about basic income. I've told you some of the conditions I think that they want, generally in any system, but it would really be beneficial for your group to maybe start thinking about reaching out and having conversations with different chiefs or or going to make a presentation. So anyway, I'm happy to help make those connections.
Thank you very much,
Thank you.
Naomi, and we definitely will follow up on that and have been doing that to a certain extent.
Okay.